Day one in the James Crumbley trial is now in the bag. We went through opening statements and a few witnesses today. We ended off the day with the state finishing its direct examination of one of the witnesses, and we're going to pick up tomorrow with the defense attorney beginning her cross-examination of that witness. There was already 2 days of jury selection, and if you haven't seen my video on that, certainly go check that out, the video that I just did on the jury selection in the James Crumbley trial. But today we're going to be jumping into the opening statements and some of the witness testimony. Now, before I begin, I just want to give a little bit of a disclaimer, and you have to understand and appreciate the situation that I am in right now. And that is that I'm a little bit in a sensitive situation because this trial is being tried literally in my home state of Michigan, and it's being tried in a courthouse in front of a judge that I'm very familiar with. And these attorneys that I'm going to be speaking about, I can quite literally bump into them very shortly after this trial, during this trial, in different courthouses, and therefore I have to be a little sensitive, and I just want to give a little disclaimer that, as everybody knows who's been watching this channel, they know that I give my opinions and I just use from the experience that I've had in trials in analyzing these type of trials that are going on and giving you what I maybe would have done differently or different strategies or different tactics, and I give some opinions about some of the lawyering in this case. So I don't want to get ostracized from the Michigan legal community by coming down too hard on some of the attorneys here. The attorneys here are very experienced. They know what they're doing, and they don't need me to give my opinion about what, their job and how they're performing their job. So I don't want anyone to take this to heart. If you're an attorney on the defense side, if you're an attorney on the prosecution side, or if you're an attorney in Michigan, please understand that I'm not trying to insult anybody. I'm just giving perhaps maybe some constructive criticisms or some of my ideas about how some of the arguments are coming in and maybe things that I may have done differently or strategies that I may have employed differently, things like that. So with that disclaimer, now let's move on to the actual trial. So the opening statements, I thought that the prosecution opened very strongly. Now, given he did have a chance to rehearse this, I guess you can call it, in the Jennifer Crumbley trial, he did do the opening statement in that trial as well. So he didn't have to completely recreate the wheel, but still, every time you have a new trial, it's back to the drawing board, though he could have already pulled from his experience in the Jennifer Crumbley trial. And this other attorney is really the first time that she is actually literally getting up there and talking to the jury. So of course, she could also have watched the Jennifer Crumbley trial. I'm sure she did. So that can help her give her ideas. But the prosecutor, I still thought, had a very strong opening statement. So let's go through some of the things that he said. He started off with November 30th was the shooting. That's exactly when the shooting happened, the tragic murder of the 4 very innocent children. And he says that James Crumbley, who was on trial, the defendant, was the one who bought the gun 4 days before this shooting. He bought this gun for the shooter, his son. We're not going to mention his name in these videos. And James failed to secure the gun. The evidence is going to show this is all, again, part of his opening statement. And it was preventable and foreseeable. Very important words. It was preventable and foreseeable. Foreseeable is going to be a requirement. You have to show that your actions or inactions it was a foreseeable result. What happened? The murder of these 4 innocent children was the foreseeable result of your actions or inactions. So he says it was preventable and it was foreseeable. And this is the way that he coined this argument. Again, it's opening statements, but you always want to kind of throw in some argument if you can. And that's what he did here. And the way that he phrased certain statements I thought were very good. And this is one of them. He said, they would be alive today. These 4 children would have been alive today if James would have seized very small opportunities to prevent his son from committing these murders. And this is a theme that you always want to stress when you're the prosecutor or you're the plaintiff in a civil suit. You want to show how all the defendant had to do was make very easy choices. He could have done some very easy, small things, seize those very easy opportunities, and then we wouldn't have been here in the first place. So that's what he's setting up here. That's what the prosecutor is saying. All he had to do was seize on some very small opportunities. So great job there by the prosecutor. He talks about how the shooter was texting his one very good friend, and this is going to come out in the evidence also. If you're watching the Jennifer Crumbley trial, this came out that the shooter had one close friend, and this is a friend who he spoke to and hung out with all the time. And he texted this good friend of his that the shooter himself was having difficulty with his mental health issues. He was having voices talk to him, and he went to his father for help, and his father told him, suck it up, take some medicine, go to sleep, suck it up, and not sending him to the doctor, where you see some of these text messages where the son, the shooter, is talking to his friend about how he really needed a mental health professional and he needed to go to a doctor. And then here's another great way that the prosecutor coined this phrase. And he said the following. He said, instead of seeking help for his son, he took his son to the shooting range. It's a great way to coin it, because these are really two unrelated events. The fact that he was ignoring his son and his son's mental health issues, at least that's the way the prosecutor is presenting it, the fact that he's ignoring that and the fact that he took him to a shooting range, the two have nothing to do with each other. But the prosecutor puts it together, and he says instead of seeking help for his son, he took him to the shooting range instead of doing that. So he's connecting the two, and he's making it that much worse. So I thought that was a great job by the prosecutor. Talks about the math sheet that has become famous already, where the morning of the shooting, the shooter drew these pictures of the gun that was bought for him 4 days before, the exact picture of the gun, drawing of the gun, and a picture of a person bleeding out on that math sheet, and some other words like blood everywhere. And this math sheet was texted to Jennifer, who then texted it to James, the defendant. And then they had a meeting at the school. And then what did James do after that meeting in the school that morning when they were all together? What did James do? He left to go do DoorDash instead of going home. Another very easy thing that he could have done. Go home, check on the gun, make sure that the gun is secure. He didn't do that. He went to work for DoorDash, and he explains also to the prosecution that DoorDash is not a job that you have to be at 9 to 5. You can make your own hours. He could have very simply gone home, checked on the gun, and then continued his DoorDash runs. But he didn't do that. Then, after he was notified of the active shooter, that's when he went home to check on the gun. Then the prosecution also lets the jury know that neither side is entitled to call Jennifer or the shooter in this case to the stand, so just letting the jury know that that's not going to happen. And then he explains that after the shooting, James and Jennifer withdrew a lot of cash and went hiding. They went missing. They wanted to hide from the police. And then he says in the very important part, he says, you're never going to hear during this trial that James knew what his son was going to do with that gun. And the prosecutor explains that if James really did know what his son was going to do, and that's why he bought the gun, then that itself, he can be charged for murder, not involuntary manslaughter. And this is where the prosecutor explains the difference between involuntary manslaughter and murder. If James knew what his son was going to do and he went and bought him the gun, that's murder. In this case, it's not that he knew what his son was going to do, but that he was grossly negligent. And then the prosecutor says that it takes a rare and specific set of circumstances for a situation to rise to the charge of involuntary manslaughter, which is gross negligence. You have to prove gross negligence. And he says that's exactly what happened in this case. You're going to hear all the evidence that comes in and shows how grossly negligent James was, and which eventually led, which was foreseeable, led to the murder. And then he also explains the difference between a proximate cause and the proximate cause, also a very important part, where he wants to explain to the jury that it's not just that one person can be held criminally culpable for this act. You can have a number of different people that are all responsible and criminally culpable for this act, because it just has to be something called a proximate cause. It just has to be a cause for what happened. Your actions or inactions were a cause for this murder and not the only cause for this murder. So he explains that to the jury, which again is very important for the jury to understand. Then he also finally finishes off that this case is not about parenting, whether he's a good parent or a bad parent. It's much more serious than that. So don't think that we're just here because he wasn't a good parent. It's much more serious than just not being a good parent. So that is essentially what the prosecutor opened with, and then the defense took over. And I want to first talk about some of the strong points that the defense made, and then some other areas that I think perhaps the defense attorney could have done maybe a little bit better. So the defense does point out that no, James did not know what his son was going to do. He didn't know at all. And she said, you're going to hear about what the school thought about that math paper, because the school has a mental health professional. And this is an important argument that's going to be made. It's certainly going to be made in this case, that if you're at the school and the school has mental health professionals, and the mental health professionals tells you that there's no imminent danger right now, even though they see that math sheet, and the mental health professionals at the school are telling you that there's no imminent danger, so then as the parents, why should you think that there's an imminent danger? And the defense attorney continues that if you don't feel that there's an imminent danger, you as the parent, meaning James, so James as the parent, didn't feel that there's an imminent danger, so then why would he do anything different? Why would he go home and check on the gun? You're right, maybe it was something easy that he could have done, but why would he? If he didn't feel that there's an imminent danger, he'll check on the gun when he gets home. Maybe. I mean, she didn't say that, but that was the suggestion that she's making, that as long as he's told by the school that there's no imminent danger, so therefore he continues on with his DoorDash job. And then she tries to say, and don't poo-poo this DoorDash job, okay? You know, everybody has different jobs. Maybe you have a job that requires you to be there from 9 to 5, but this is a responsible parent. Hey, she doesn't say all this, but this is what she was suggesting, really, if you read between the lines. This is a responsible parent, and he needs to work. And he needs to work for a living. And even if though he's working for DoorDash and he can technically set his own hours, but still he wants to be responsible and get on the road and start doing his job. He doesn't want to start running home and checking on things and taking his son home and babysitting her son. Maybe he doesn't want to do that. He wants to work. He needs to work. So that's why he was continuing his day normally as a DoorDash driver. Now, some parts, and that was essentially, maybe she said some other things also, but that was essentially the defense attorney's opening statement. And I think that an important part that should have been stressed during opening statements is, number one, everyone's going to know who's been watching my channel, reasonable doubt. You've got to talk about beyond a reasonable doubt. And from what I saw from the reports during the jury selection, I didn't see so much that she was talking about reasonable doubt, that the state has to prove their case beyond a reasonable doubt. It could be that it was spoken about, could be the judge told the jury about it. It could be that the defense attorney spoke about it. It could be the prosecutor spoke about it during jury selection. But even if they spoke about it during jury selection, it's something that you want to say again. You want to stress it. And the rule is, if you feel that you said to the jury that the prosecution has to prove their case beyond a reasonable doubt too many times, then what's the rule, everybody? Say it again. Exactly. You want to continue hammering home that this is beyond a reasonable doubt. It's not just more likely. It's not just by clear and convincing evidence. It has to be more beyond a reasonable doubt. And that's something that I feel should have been stressed during opening statement. Just remind the jury. Now, another thing that I feel that she should have also spoken a little bit more about during opening statement. This is something that you can use. The judge, actually, if you watch this trial from the beginning, the judge, before the opening statements, reminded the jury, and she read from the instructions, reminded the jury what the charges are, the 4 counts of involuntary manslaughter that James is being charged with, and what the elements are to prove that. What are the theories of this case? And she said essentially the definition of gross negligence. She said that it's more than carelessness. And then she says more than carelessness, it means that you have a reckless disregard for the results that will follow from your actions or inactions, right? So it's a reckless disregard. That's how the judge said it. So wouldn't it be a good idea to get up there as a defense attorney and say, ladies and gentlemen, I just want to piggyback off what the judge just instructed you. And therefore you're not asking the jury to take your word for it. This is something that they just heard a minute ago from the judge. The judge just told you that in order to find gross negligence, it's more than carelessness, which means that throughout the trial, as the evidence is coming in, you may feel that my client was careless and he should have done certain actions, or he should have been more careful. He should have been more careful storing the gun, should have been more on top of his son's mental health issues. And maybe you'll find even that he was careless. But the judge just told you that that's not enough. Gross negligence is more than carelessness. It's a reckless disregard for the safety of others. And then you say, and also to piggyback off the prosecutor, my brother Counsel, the prosecutor who just spoke to you. Again, I'm not making any arguments. This is what the prosecutor told you. This is what the state has just told you. The state just told them, they just agreed themselves that it takes a rare and specific circumstances to be able to charge and find somebody guilty of involuntary manslaughter. It's very rare, ladies and gentlemen. So you may be finding a lot of problems with the parenting of my client, James Crumbley. I'm just putting myself in their shoes. You may find that. You may find that he even acted negligently at certain times, and he acted carelessly at certain times. But you still have to write on that verdict form, if all the evidence comes in, that my client is not guilty. And this all was not stressed during the opening statement. And I think that it was so important. I think you should stress this during opening statements so that you can tell the jury, as the evidence comes in, I want you to be thinking about this. Is this careless? Or is this rare and a specific circumstances which rise to the very high level of gross negligence, of reckless disregard for safety, essentially? And again, I think that it should have been stressed during opening statements. Okay, so that's what I have to say about the opening statements. Let's jump into some of the witnesses. So we had Molly Darnell, who was a teacher at Oxford. She actually was shot. She was injured in her arm. And essentially, really what came out from her testimony, aside from the mayhem that she testified about, was the fact that the shooter, his stance, his shoulders were squared, his gun was out, and she was talking about that. And that's really the more important part, at least what's relevant for this case, that came out. Then we had Edward Rogrowski, who now works for the Secret Service. He also does cell phone analysis. So he was one of the responding officers to the scene, and he actually saw the video of the actual shooting in the Oxford High School. And he describes that, and obviously that's very emotional, very painful. Then he talks about the text messages that he's seen from the different phones that he was able to download all that information. So he talks about the text messages between the shooter and his very good friend, about talking about his mental health issues, which we spoke about during the opening statements. He also showed a video where the shooter sends his friend a video. Listen to this. He sends his friend a video of him playing around with this new gun that was bought for him. And it was both when James and Jennifer were home at the time. And their son is playing with this gun, who's very obviously not secured. And he texted his friend that his dad left the gun out. So there again, you're seeing that they're just leaving guns out. Maybe that's even more than careless. All right, well, that came out. Then you have October 30th was when the shooter's friend, this good friend, was going to go to Wisconsin for treatment for OCD. Apparently he had a bad case of OCD. He needed treatment in Wisconsin, and he completely dropped off the grid. So this is his one very, very close friend who had something like 20,000 text messages in a short amount of time just between the shooter and his friend, and now he just drops off the map. Now, November 9th is when James begins working for DoorDash. November 26th is when he bought the gun for his son. And the son, the shooter, starts posting pictures that he just got this new gun. It's his gun. He starts posting it. Ask any questions that you want. He's very excited about it. And November 27th, that's when Jennifer Crumbley goes to the range with the shooter. And she also posts about that they're trying out his new present, the shooter's new present. And then those images were deleted. November 29th is when they get a voicemail. Well, Jennifer gets a voicemail from Pam Fine. Pam Fine was someone who works for the school, and she says that she noticed that, one of the teachers noticed that the shooter was looking up ammunition in school, looking up different ammunition for this new gun that he just bought. And the voicemail is not overly concerned. Pam Fine is not overly concerned with what the shooter was doing. She says it's perfectly normal to do that at home. It's just not the right thing to do at school. So that obviously is going to be used both by the prosecutor and the defense. The defense is going to say, look, they didn't even think that that's significant. And the prosecutor is going to say, look, you have all these red flags, and he's looking up ammunition. What do you think he's about to do? So you're going to be hearing arguments both ways on that. Then you have November 30th. November 30th is the day of the shooting, and Jennifer gets a text with the math paper where these disturbing images that the shooter drew on it is on this math paper. So she gets this image 9:30 in the morning. She texts it to James. She says, call now, emergency, and she's heading to the school. They both head to the school. They meet with the school at around 10:35. They leave the meeting at 10:54, and then this is all obviously tracked through the phone that James goes about doing his DoorDash job right after. And that's when afterwards they get an email at 1:09 that there's an active emergency. He tries to call the shooter, and that's when he goes home to check on the gun. Jennifer calls James. While Jennifer is calling James, she texts her boss, oh my gosh, I think that the shooter is my son. And then eventually James calls 911, talks about the gun that was missing at his home. So that's essentially where we left off in today's testimony, and tomorrow we're going to be hearing cross-examination from the defense attorney. But something interesting also happened at the end of trial today after the jury was dismissed, and that was that there was a stipulated order. There was an order entered into, which was agreed to by both the defense attorney and the prosecutor, that apparently, which is not clear from the hearing, but apparently what it seems is that James is having some sort of communication with people that he shouldn't be about this case. And therefore, they wanted some sort of gag order that James not be allowed to discuss or communicate about this trial with anybody other than his lawyer and a clergy. So that stipulated order was entered into, however, with the caveat that obviously he is allowed to review documents, prepare for his trial, look things up online, do some research on his own, but just his communications are going to be limited to his attorney and a clergy person. So that is where we left off today. Please, if you haven't yet, subscribe, like this video, and we will be continuing to follow this case and bring you more analysis. That will be it. See ya next time.